Good afternoon. Today I'm joined by Rajiv Nath, the forum coordinator of the Association of the Indian Medical Device Industry. My first question to you regarding the bill is that the Drugs, Cosmetics and Medical Device Bill is going to replace a colonial era 1940 bill. What changes have taken place in the regulatory framework of medical devices, and what is the need for a bill like this right now?
Okay, for medical devices, the first medical device, I think, got regulated in the year 1989, if I'm not mistaken, which were syringes, needles, infusion sets, and transfusion sets. And that time they were regulated as drugs under the Drugs Act. And subsequently, in the next 30 years or so, hardly 30 medical devices, item by item, were notified as drugs. And in terms of patient safety, because there was no separate regulation for medical devices. Then in 2016, the government came out with the medical device rules, made effective from 2017 January, which was a shift from the drug rules. So you have the act, then you've got the rules, and you've got the schedules, and then you've got the guidelines. So the rule book was shifted from the drug rules for medical devices as per the international harmonized regulations, keeping the best practices into consideration. And that time we were assured that we'll be having a separate act coming into play. Also, the National Health Policy of 2017 and the Parliamentary Committee recommendations of 2022, as well as assurances from the Ministry of Health given to us for a separate act. And Niti Aayog in 2019 came out with a draft bill to regulate medical devices separately from drugs. But what has been tabled or is being tabled to the Parliament, which is the list of bills which will be submitted to the Parliament in the monsoon session, is a bill covering drugs, cosmetics, and medical devices as a new bill to replace the earlier bill. However, unfortunately, this bill is a lost opportunity. It is not progressive. It is not modern, as some would like us to think it is in the direction. It is not. So we are in dialogue with the government to bring around a recall of the bill and to give us a separate law book, which would be encouraging Make in India and encouraging the access to innovative medical devices by consumers.
Why do you think this bill is not progressive? Are there any problems with it?
Yes, huge problems. So first and foremost, usually in the last 10 years or so, the various progressive countries have brought in either new laws or they have revamped their regulations. Now, the countries who brought in a separate law for medical devices, among them are Europe, UK, Canada, Brazil, Japan, and even a country like Saudi Arabia. So that's the big change which many countries are going forward. Now, medical devices are different than drugs. We're not like a homogeneous liquid or a homogeneous chemical. It's typically an assembly of components to make an equipment, like you make a car, assembly of various components. So this is also like an engineering item. You are assembling various components, whether you make a wheelchair or you make a X-ray machine or you make an ultrasound machine or you make an orthopedic implant. So it is a combination of various products. Even a heart valve will be having an assembly of various products over there. So it's more to do with the engineering. It cannot be so homogeneous. And normally by progressive laws and systems, what we seek, like for the food also came under regulations under a separate act a few years back. And the Food Act also is pretty much decriminalized. It tends to motivate manufacturers to improve the food safety aspects, the hygiene aspects. There are audits that take place and a point system that is given for manufacturers to improve upon and to monitor their progress. Simply for medical devices, that is something that what we were seeking, that there'll be an audit system for making sure that we are disciplined, we are following the rules and regulations. And there'll be post-market surveillance to keep sure that unsafe products are not coming into the market. And if they are, then there can be preventive and corrective actions that can be taken by the government in consultation with the manufacturers. But this is done in a system whereby you are not threatening manufacturers by always telling them that if you do something wrong, you'll be put into jail. So, okay, if you are not a licensed manufacturer and you're making products illegally, then of course, that's a criminal activity. You have to be punished accordingly uh, with a threat of jail. Understandable. But somebody who has come forward and wants to be licensed, willing to be regulated, willing to follow particular discipline, normally there may be some mistakes some employees may make from time to time. These need to be corrected and improved upon. Now, very rarely they may result in a death or a serious injury, like leading towards surgery. That's very, very rare. But usually, when minor issues happen, typically it's better to have more effective quality management systems or a regulatory administrative approach in terms of correcting the manufacturer. So, in today's date, for children also, you don't use a whip anymore, you don't slap them anymore. Teachers are not allowed to do that. So parents and teachers have to coax, motivate, educate, and get the best out of children and allow them to be innovative and smart kids and smart adults in future. The same thing over here. One has to trust manufacturers, and that has to be the way forward in terms of smart manufacturing.
Yes. You mentioned about the criminal activity and the penalties and the need for a separate medical device bill. Could you please elaborate on if there is another like why there is a need for another legislation for medical devices and how it's going to be different?
Okay. Now, when an engineer comes out and he's asked to read the current drug act and then the medical device rules, it's a pretty thick book. It's very discouraging for him to even think of continuing to make or to venture into the medical device field. So, first and foremost, having a thin book, a separate law book like it's there in other progressive countries where the law is defined and the rule book is defined, it is in simple language, it is not complex, it is reasonable and implementable, then somebody can follow the law. If somebody cannot read the law and it's too complex, you do without understanding what is requirement, what your role and responsibilities are, what other people's role and responsibilities are, then mistakes are bound to happen. Then you're bound to trip and fall. Then somebody is going to come tomorrow and say you're not doing the correct thing. You're doing things illegally. That is not the right way. So best is to have a reasonable implementable law which can be easily be understood by engineers and scientists. Don't make it designed for lawyers. Don't make it having too many guessworks. What does this clause mean? It means this or it means this. And again, what is the purpose of the law? The purpose of the law is number one, to safeguard patients. Number two, to make sure the marketplace is having access to only safe medical devices. Number three, not to curb access to innovative products. Number four, make sure that there is adequate domestic manufacturing, which will allow competition to take place, which will drive down pricing and make medical devices affordable. If we are going to be 80% import dependent, and every few months the rupee dollar rate is going to be falling adversely, the prices are always going to be going up, and it's always going to be more expensive for the consumers.
What is the role of the CDSCO? How much power do they have in regulating the drug quality? And do they?
So currently, CDSCO is the regulator
Hmm.
for drugs, and medical devices are currently called drugs under the Drugs Act. This was a compromise which we had agreed to on a temporary basis when we were assured that we would be given a separate law book in future. But when the medical device rules were framed in 2016, 2017, this was our understanding with the ministry that a separate law book will be forthcoming. And this is a temporary situation where engineering goods, we're not pharmaceuticals. So you can't call a defibrillator or an X-ray machine or a wheelchair as a drug. But we agreed to accept that on a temporary basis because we did feel the need. Yes, the government is right. in terms of patient safety, devices do need to be regulated. And until the law book is made separate, let us use the current Drug Act for going forward. And CDSCO was the regulator for that. Now, unfortunately, CDSCO is basically manned mainly mostly by pharmacists. And pharmacists or chemical specialists or a few microbiologists who are seeing things from the drug angle or study from the drug angle, from vaccines, from vials, which are made in a sterile atmosphere, is different than in the case of medical devices, where you may pack a product and do sterilization after you pack the product. So it may not be a sterile atmosphere. The packaging is designed to give you sterilization post-packaging and post-assembly has taken place. So it's a different concept which is required and a different kind of regulatory system that is required. Internationally, most of the developed countries in the world, they have realized that it is very challenging to have a huge manpower of inspectors to regulate medical devices on factory by factory basis. Whether somebody is making something simple like a stretcher or even something like a thermometer, or to something as complex as a heart valve, okay, or an MRI machine. It requires different kind of expertise. No inspector would be having the expertise of chemical engineering, mechanical engineering, electronic engineering. So mix is required. So they started delegating the task to third-party certification bodies who would verify that the manufacturers are following the regulatory norms in terms of quality management systems, in terms of technical file documentation, in terms of risk mitigation. Now, in India, this has also been started in the medical device rules. So the low-risk medical devices are being regulated under CDSCO, and the state licensing authority, but the audit is done through these third-party certification bodies who are accredited by Quality Council of India's NABCB accredited certification bodies. They come to our factories and do an audit as per the regulatory requirements over a 2-day or a 3-day or a 1-week time period, depending how big your factory is. So the compliance is more, I would say, strict and more closely monitored. Going forward, what we expect in the separate law is that the people who are going to be auditing us, not only auditing us, but the regulators who will be supervising the certification bodies, and even for Class C and Class D products, which are currently not coming under third-party certification, they'll be coming under a category of medical device officers or auditors. And these medical device officers will not be having the old mindset of Inspector Raj. It will not be search and seize kind of an attitude. It will not be like a policing kind of an attitude. It will be an attitude for seeking continuous improvements. So they'll be coming from the engineering background or the scientific background, and will be having a different mindset approach than the people who have been regulating us in the past. So with progressive times, a different kind of thought process is required to bring the best out of manufacturing.
Okay. So what you're saying is it is largely dominated the regulatory process by pharmacists, and there needs to be
Yes, currently it is highly dominated by pharmacists. Yes, so in CDSCO, for example, there are hardly 23, 25 engineers and scientists who have been hired recently to be developed as medical device officers. So they have to be still groomed. They have to audit the factories, understand the quality systems and the standards internationally, and then to be put into service properly for the benefit of the country. Meanwhile, the government or CDSCO or the state regulators have just redesignated pharmacist-based inspectors as medical device officers. So they still think from the drug rule perspective, that's what their expertise are. They still see things from the pharmaceutical industry and compare what they've seen in the pharmaceutical industry and try to apply that knowledge onto medical devices. Now, it's like asking a police officer to use his training to an army guy. So what army needs is different than what is required for policing. Both may be for security, but both have different specialization and different areas of working of quality of. So we cannot operate on the same manner like the pharmaceutical industry. And even if something goes wrong, the punishment cannot be like in the pharmaceutical industry, because these are engineering goods. Mistakes will happen. You can't have everything which is completely homogeneous and uniform. So just because in pharmaceutical industry, if something is substandard and you say there's going to be a criminal case against the manufacturer, if you start doing something like that for medical device industry or for car industry, people will stop making cars and people will stop making medical devices. So this is where we need to be having a different approach, even by CDSCO, the regulator. It's not done like this internationally.